Hello and welcome to topic 2, where we're going to be learning about the institutional powers and constraints that are placed on the Supreme Court. And this is the first lecture for topic 2, and we're going to be talking about the powers of the Supreme Court. So for topic 2, you're going to be reading chapter 2 from the textbook. And chapter 2 covers two main issues. The first thing that it covers is the power of the Supreme Court. So you'll be learning about its main power, which is the power of judicial review, and the landmark case that establishes judicial review, Marbury versus Madison. You'll also be learning about the constraints that are placed on the power of the court. And so we're going to be learning about whether the court actually has jurisdiction or the authority to hear a case. You'll be learning more about that in the case Ex parte McCardle. You'll be learning about whether or not a case is appropriate for judicial resolution, like whether or not the court is actually the place to solve this dispute. And in that, we'll be talking about the concept of justicability. And then we'll talk about whether or not the appropriate party has brought the case to the court, which is standing to sue. Now, this chapter, chapter 2, and also the previous chapter, chapter 1, all provide you with foundational concepts that you are necessary to understand the cases that we're going to be reading throughout the course of the semester that deal directly with civil liberties. But this chapter is still a very important chapter, but it's one of the foundational concepts chapter. In this lecture, we're going to be talking about this first thing, the power of the Supreme Court. In the next lecture for topic 2, we're going to be looking at the constraints on the power of the court. So let's get started. Okay, so let's dig into Marbury versus Madison. And so to fully understand the importance of Marbury versus Madison, we need to do a couple of things. One thing we need to do is to define some key terms, and then we also need to describe the historical and political context of Marbury versus Madison. As you're going to see from the lecture and also reading in your textbook, that to really fully understand why Marbury versus Madison is important and why this case actually came about, is really understand some of the changes that took place early on in the early 1800s in the United States as it relates to political parties. So first, let's define two important key terms, judicial review and jurisdiction, and then after that, we'll move on to talk about the historical and political context. Okay, so what is judicial review? Now, for some of you, you might be familiar with the concept of judicial review, particularly if you've taken an American government class. How judicial review is defined by your textbook as the court's power to review government actions and invalidate those actions that are incompatible with the Constitution. So basically what that means is that the court has this power to hear cases that deal with particular laws that where people claim that these laws might be unconstitutional. And so the court looks at these laws and they ask themselves, are these laws unconstitutional? And if they are, then they can basically nullify that law. And so it's this tremendous power that the Supreme Court has. Let me give you two concrete examples of the of judicial review from some recent cases to give you an example of the judicial review in action in a contemporary context. So one of the cases that you're going to be reading about later in the semester and that is covered in the book, The Most Dangerous Branch, is the case that's known as Citizens United. But the formal name is Citizens United versus the Federal Elections Commission. And what this case is about a congressional act, a federal law. And it was called the Bipartisan Campaign Reform Act. And some of you might remember this because this was a law that was spearheaded by a Republican, John McCain, and by a Democrat, Wisconsin former Senator Russ Feingold. And what this campaign law did, it did many things, but one of the things that it did that was pertinent to this case is that it prohibited independent expenditures by corporations and by unions. And so basically saying that corporations and unions couldn't couldn't spend money on the behalf of a particular candidate. And now Citizens United, they were a corporation that was, had made a movie about Hillary Clinton, and that the broadcasting of that movie that was too close to the time of the election, that was deemed as a violation of the Bipartisan Campaign Reform Act. And they screamed foul, and they said that that provision of the Campaign Reform Act violates the First Amendment. And the court agreed with Citizens United. And so basically, they nullified that provision within the Bipartisan Campaign Reform Act, sort of opening the doorway, saying that part of the law was unconstitutional, exercising judicial review, nullifying that part of the law, and basically opens, why this is a controversial case is because it opens the doorway for unions and political action committees to spend money on campaigns in a way that is, a lot of money, and because they say that is their right under the First Amendment freedom of speech clause. Another example, so that's an example of judicial review nullifying a federal law. Obergefell v. Hodges, which you're going to be reading about later in the semester, is about same-sex marriage. And this is an exercise of judicial review of state laws. And so judicial review, what the power of judicial review applies to state laws, local laws, federal laws, and also the actions of the president or the federal executive branch. Obergefell is basically saying that when states have on their books laws that define marriages between a man and a woman, that it violates the Constitution. And the Supreme Court, in a narrow decision, said yes, that those laws are unconstitutional because they violate both the Equal Protection Clause and also the right to privacy clause that is in the Constitution, which we'll talk about later in the semester. So both of those are good examples of judicial review in a contemporary context. Now, as we know from reading this chapter, judicial review is not a power that is explicitly stated or enumerated in the Constitution. It's a power that the court basically creates. It's a power that's created by the decision in Marbury versus Madison. And there's some controversy behind judicial review, and we're going to talk about those at the end of the lecture. But as you're going to see in John Marshall's ruling in Marbury, that it is a power that's necessary for the functioning of a constitutional democracy. Okay, so we've talked about judicial review. Let's now talk about the second key concept necessary for understanding Marbury versus Madison, which is the concept of jurisdiction. And we talked a little bit about jurisdiction in topic 1, both the chapter and in the lecture. So one of the key questions in Marbury versus Madison is whether a federal law expanding the original jurisdiction of the Supreme Court is constitutional. So that's, this is a case that revolves around sort of some kind of minutia in terms of law, although the case itself the background of the case is super exciting. And so, this is about whether or not a law is constitutional. Spoiler alert, the court decides that the law that expands the original jurisdiction of the Supreme Court is unconstitutional, and they overturn that provision of the law, and thus they create the power of judicial review. Basically, John Marshall, the Chief Justice, says that the Supreme Court has that power to void laws that are unconstitutional, and they said that the law that was brought before them in Marbury versus Madison was in fact constitutional. So what is jurisdiction? Just let's make sure that we are on the same page when it comes to that concept of jurisdiction. And when we talk about original jurisdiction, what do we mean? Okay, so we learned about judicial review and defined that. Now let's turn our sights to talking about the concept of jurisdiction. Jurisdiction is basically having the authority to hear a case. In other words, it's a court having the official power to make legal decisions and judgments. And so, courts have different authority to hear a case. Here's some good examples. And for those of you who have taken my criminal justice class, you'll be very familiar with this idea of courts of general jurisdiction and courts of limited jurisdiction. And because courts have different types of authority to hear a case, or they have different types of jurisdiction. And so, if you've taken a criminal justice class, these are some good examples of like limited jurisdiction courts that have limited authority to hear the case. So family courts are basically like you can only hear cases that have to do with family law, that you're limited, the court's authority is limited in terms of they can only hear divorce cases, custody cases, etc. Juvenile courts, good example of limited jurisdiction. They only, or if that's what the law says, only have the authority to hear juvenile cases. Just when you think about the general courts in Wisconsin, that the circuit courts, the trial courts of Wisconsin are divided in terms of jurisdiction. And so if you commit a crime or are involved in a civil suit in Waukesha County, you're going to go to the trial courts that have the jurisdiction to hear Waukesha County cases. They don't have the jurisdiction to hear cases from Milwaukee County. And so those are some like just general examples of what jurisdiction means. Jurisdiction is really an important concept because it relates to the rule of law and how power is defined and limited by law. And so, we have a constitution, and the constitution basically tells us what the specific jurisdiction of the courts are. We don't let it up to courts to define what their own jurisdiction are, that we either have a constitution that lays down what the jurisdictions are, or we have federal law or state laws that defines jurisdiction. And that it basically, places limits on the exercise of power, which is a key concept within a constitutional democracy. So when it comes to the Supreme Court of the United States, it's the Constitution of the United States, in particular Article 3, and in particular Article 3, Section 2, that establishes what the authority of the Supreme Court is, or establishes what the jurisdiction of the Supreme Court is. And last class, we talked about the difference between courts of original jurisdiction and appellate jurisdiction. And Article 3, Section 2 tells us it establishes what the original jurisdiction of the Supreme Court is and what the appellate jurisdiction is. So let's just put this up here, that this is the language from the Article 3, Section 2 of the United States Constitution, because it's there that we have spelled out the original jurisdiction and the appellate jurisdiction of the Supreme Court. So original jurisdiction, as you know from last class period, it's hearing a case for the first time, right? That, in other words, the case originates in that court, okay? They hear it for the first time. It's where the trial takes place and the original decision making goes on. And, as we also know from last class period, that that the Supreme Court, while it's usually an appellate court, it does have some instances where it can hear the case for the first time. So the Constitution says in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. It also goes on to tell us about the appellate jurisdiction of the Supreme Court. And the appellate jurisdiction is hearing a case after a lower court has heard it. And as we know, the vast majority of cases that come to the Supreme Court are heard by a lower court first. And it says there from the Constitution, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make, okay? And I have that highlighted in red because when you get to the case ex parte McCardle, that's going to become a really big issue in that case. That basically the Supreme Court has appellate jurisdiction, but the Congress can actually step in and say, while you do have appellate jurisdiction in all of these kinds of cases, federal cases dealing with federal law and federal and constitutional matters, Congress can actually strip or reduce that appellate jurisdiction by passing a federal law. Okay, let's not get too hung up on that because you're going to be reading more about that in the textbook. But it's important to know what jurisdiction means. And for Marbury versus Madison, it's really important to understand this concept of original jurisdiction because that case revolves around the expansion of the original jurisdiction of the Supreme Court. All right, that's it for key concepts. Let's move on to take a look at the historical background and the political context of Marbury versus Madison. Okay, so let's look at the historical and political context of Marbury versus Madison. Marbury versus Madison, this case springs out of the election of 1800 and the presidential election of 1800, but also the congressional elections as well. And it's historic because it's the first transition of power between rival political parties. And not only that, it is peaceful. So prior to 1800, that either the presidency and Congress there were no political parties initially, but as political parties developed, that there was rival political parties, but the rival political party didn't win, and so the transfer of power was between the same party, right? But the 1800 is the first time where the rival party actually wins, and that there is a peaceful transfer of power. If for those of you who are maybe Hamilton fans, the musical Hamilton, you'll see the rise of the rival political party, and so that there were two political parties that soon developed after the ratification of the United States Constitution. The one party was known as the Federalist Party, and that, George Washington was a Federalist, Alexander Hamilton was a Federalist, John Adams was a Federalist. And then there was a rival party that developed that was created by Jefferson and his buddy, James Madison. And they called themselves the Democratic Republicans. And so in 1796, Jefferson challenged Adams in the presidential election, but Adams won. And so the Federalists prevailed. But in 1800, it's a rematch between Adams and Jefferson. And in this time, Jefferson wins. And it is a hugely contested, or it's a hotly contested election. The election is really close. There's a lot of ill blood between John Adams and Jefferson really wanted to win. And in fact, there's a campaign that you can watch I put on our Canvas site. It's not really, they didn't really have campaign ads then as such, like TV ads, but the campaign ad is it uses the words and the language that Jefferson and Adams used during the course of the campaign. So it's a fun ad. Go ahead and take a look at it. And so it's hotly contested. The Democratic Republicans win big, but the Federalists aren't going to go quietly into the night. As you know, after an election, there's a period of time between the election and then when the next president or the next Congress is seated. There's a period of time where those who lost election actually continue to serve in the government. And so that even though the Federalists lost the majority in the House and they lost the presidency, that while they were still in office, they weren't going to go into the night quietly, and they were going to make changes that were really going to benefit the Federalist Party. So while the Federalists were still in office, they decided that they were going to pass laws that were going to benefit the Federalists, even though the Federalists had lost the election. And that's what's known as, a lame duck Congress or a lame duck presidency. A lame duck, well, see, there it is up in the corner. It's a duck and it's wearing a cast. Well, a lame duck is not something anybody wants. And a lame duck Congress or a lame duck president is basically like, hey, you lost the election, but you still have several months in office where you can actually continue to govern. And that's exactly what the Federalists did. And what the Federalists did is they were like, we lost, but we're going to create a bunch of new courts, and then we're going to pack those courts with a bunch of Federalist judges. And so they passed two acts. One is the Circuit Court Act of 1801, which creates a whole bunch of new federal courts and therefore a bunch of federal court justices that could be put in those courts. And then the Organic Act, which is a court that creates new courts for the District of Columbia. And so, the Federalists are like, hey, we're going to leave our mark. We created all these courts, and then we're going to pack those courts with Federalist judges. And so, just sort of think about it from a contemporary perspective. Let's say that, right now the Democrats have the presidency, and they also hold the House and the Senate. And then let's say that, come let's say the presidential election, let's say that the Democrats lose everything, right? They lose the presidency, they lose the Senate, they lose the House, but they still are in control of those three branches of government. Imagine if they were like, hell, we ain't going to go quietly into the sunset. We're going to like pass a bunch of laws, expanding the number of justices on the Supreme Court, creating a whole bunch of new courts, and we're going to pack them with a bunch of liberal Democratic justices. I mean, people would be outraged. And that's basically, people were outraged at this time because that's what the Federalists were doing. And so the current Chief Justice of the Supreme Court retires so that Adams can replace the Chief Justice with a Federalist, and he replaces that Chief Justice that retires with John Marshall, who now becomes a new Federalist Chief Justice. And basically, Adams uses these acts to pack the judiciary with Federalists. Okay, so the Federalist Congress passes laws that create all of these new federal courts. And you know what that means? When you have a bunch of new federal courts, you need a bunch of new federal judges. And as we know, that there's a process that takes place when it comes to putting people on the federal courts, putting a judge on the federal courts. And so as we know, in order to become a federal judge, first the president needs to nominate a judge. And so John Adams, as a Federalist, is like, we've got all these new judgeships. I'm nominating a whole bunch of Federalists to take over and be placed on the bench in those new courts. And you have this Federalist Senate, they're like, confirm, yes, so they confirm a bunch of these Federalist judges. So they're nominated, they're confirmed by the Senate, and that's not enough, though, to become a justice, a federal judge. You actually have a formal commission, like a letter that is sent to that judge, basically saying that, in fact, you've been nominated and confirmed by the Senate, and then you receive this, and in receiving the commission, you become the judge. And so it needs to be signed, sealed, delivered, then you become a judge, and if it's not signed, sealed, and delivered, you don't become a judge. No commission, no judgeship. Now, the Secretary of State is responsible for delivering these commissions. And when John Adams was in office, he was busy till his last days, signing these commissions and having them sent off. But so the Secretary of State is the one who's actually responsible for delivering these commissions. And not all the commissions of John Adams' appointments were actually delivered. Most of them delivered, but a handful of them were not. And as you'll read in the textbook, when Jefferson takes over as President of the United States in March of 1801, they started in March, not in January as we do today. Jefferson walks into his office and he actually finds a pile of commissions, 5. And he's super pissed off about what the Federalists did, right? That it's like, he did not want to contribute to this court packing and having one more Federalist judge. So he said, you know what? There's the commissions. I am not going to deliver them. And he didn't deliver them. Well, what do you know? 5 of the commissions weren't delivered, and you know who didn't get their commission? William Marbury never got his commission to serve on the federal court as the Justice of the Peace. And he really felt that it was super unfair. And who wouldn't be, right? What if you had been nominated, and what if you've been confirmed by the Senate and you're just like, all I need is the paperwork, and the paperwork never came? You'd be really pissed off. And William Marbury really felt that it was unfair that he was denied something that he was rightfully owed. And so he was like looking for a remedy. It's like, okay, I was nominated, I was confirmed, commissions were never delivered, but I need some justice. And so he's looking for a remedy on how to get his commission. And he turns to a federal law, and that it's the Federal Judiciary Act of 1789. And the Judiciary Act establishes the lower court system in the United States, among other things. So he's like, how am I going to get my commission? And he turns to the Judiciary Act of 1789, and he looks at Section 13 of the Judiciary Act. And in that section, it basically gives the Supreme Court the power to issue a writ of mandamus, okay? And you're like, Professor Hankinson, what the heck is a writ of mandamus? Well, what a writ of mandamus is that it's an order from a superior court to either a lower court or to some actor within a government agencies or an institution. It's basically an order telling them to do their job, right? It's basically if somebody doesn't do their job, that the court can issue a writ of mandamus saying that you have a legal obligation to do this, so you are ordered by the court to do it. So Marbury is like, that's the solution to my problem. I am going to, come to the Supreme Court, and I'm going to ask the Supreme Court to have to issue a writ of mandamus to James Madison, who was the Secretary of State under Jefferson, and I'm going to have the Supreme Court use that provision of the Judiciary Act of 1789, and the Supreme Court is going to force James Madison to deliver my commission. And he thought he had a really good remedy. Okay, so you get the historical context and the political context for Marbury versus Madison. You have a pretty good grasp on the facts of the case. So what is the question that's before the court in Marbury versus Madison? The question is does the Supreme Court have the constitutional power to issue a writ of mandamus in order for an appointed judge to secure his commission? And the decision of the court, or what the court rules is that by a 4-0 vote, the court ruled that the power for the Supreme Court to issue writs of mandamus, it's not in the constitutional. And that Section 13 of the Judiciary Act that gives the Supreme Court that power, that provision of the Judiciary Act is unconstitutional. It's doing something that is not constitutionally allowed. And John Marshall, the Federalist, new Chief Justice of the Supreme Court, writes the opinion. So let's take a look at this opinion. So the Supreme Court rules that the provision of the Judiciary Act of 1789 is unconstitutional. So how does Marshall reach, and how does the court reach this decision? Well, he asks a series of questions, and then in his decision, he answers those questions. And so the first question he asks is, does Marbury have a right to this commission? And he says, yes, he absolutely does have a right to this commission. He was nominated and he was confirmed by the Senate, and therefore he has a right to be seated as a judge. It says if he has a right to the commission, that this is the second question in Marshall's decision. It says, okay, if he does have a right to the commission, which the court says that he does, do the laws of the country afford Marbury a remedy, right? And he says, yes, the country does afford a remedy to this. So because he's been treated unjustly, his rights to this commission have been violated, the country deserves it must give him some repair to this injustice that he has experienced. Okay, so Marbury has a right to the commission and he deserves a remedy, bringing us to the third question that John Marshall raises in his opinion. Okay, so if so, he has a right and he deserves a remedy for his rights being violated. Is the remedy the Supreme Court issuing a writ of mandamus to the Secretary of State, Madison, James Madison, basically the court ordering James Madison to deliver the commissions? And they say no, that this is not the remedy. Why? Why is for issuing a writ of mandamus to Madison not the remedy? Basically says that Article 3 of the Constitution establishes the original jurisdiction of the court, not Congress, right? And so if you go directly to the court asking it to issue a writ of mandamus, that the court is hearing that for the first time, it would be within its original jurisdiction realm. And so he basically says that it's Article 3, it's the Constitution that establishes the original jurisdiction of the court. It's not law. It's not Congress passing a law. He says that Section 13 of the Judiciary Act expands the original jurisdiction of the Supreme Court, giving it this power to issue a writ of mandamus. And the Constitution does not give Congress the power to do that. And so therefore, since the Constitution does not give Congress the authority to expand the original jurisdiction of the Supreme Court, Section 13 of the Judiciary Act is unconstitutional, and therefore it's null and void. So while William Marbury has a right to the commission, and while he deserves a remedy, the remedy for his injustice is not forcing the court to give James Madison a writ of mandamus because the law establishing that power is unconstitutional. So, unfortunately, for William Marbury, he's actually never seated on the federal court. No commission for Marbury. Sad face, he never becomes a federal judge. So after learning about Marbury versus Madison, you could probably guess why it's an important case. But let's talk a little bit about why it is in fact important. Well, it's important because it establishes judicial review. It establishes a tremendously important power for the Supreme Court of the United States. And as you're going to see in many of the cases that you're going to be reading this semester, the court exercises this judicial review. They look at law and they look at the law and ask, is it unconstitutional? And if it is unconstitutional, that law has to be it can't be in power anymore. So it's a huge power that the Supreme Court has. Marbury versus Madison is also important because it provides a vigorous defense of the Constitution, of the separation of powers. And it also shows and establishes the Supreme Court as an important power player, an important institution within our three branches of government. When you're reading through John Marshall's opinion, and I really encourage you to do, it's a little tough, and I would love if you come to office hours and we could walk through some of the questions you might have about his opinion. It's one of the more difficult ones you're going to be reading this semester, so they get easier as we go on. But you'll really basically say that, John Marshall will be saying in his decision, why do we have a Constitution if we're not going to follow the Constitution? The Constitution is really important. And if Congress or any legal body could just write a law and violate the Constitution, then the Constitution, and that we allow that law to be enacted, then the Constitution becomes meaningless. And so it really, sort of establishes the importance of the rule of law, and in particular, the paramount importance of our written Constitution. It also establishes the interplay between the branches of government, right? The Congress does something and the Supreme Court is there saying, nope, you can't do that. You're engaging in something unconstitutional. And so it sure shows that, there's a check and balance and a vigorous interplay between the institutions. It also, as we know, that the court was supposed to be seen as the least dangerous branch, like the branch that really wasn't that important. Now, the book you're going to be reading is saying it's actually become the most dangerous branch because it's exercises its power in maybe ways that too much, in ways that it wasn't intended. But John Marshall basically, says to, with his opinion that the Supreme Court, we've got power and we're going to use it. And they do use it. It's also important because it puts into action some of the legal methods that you've learned about during the course of, in topic one. John Marshall's a pragmatist. He knows that if he forces President Jefferson, the Democratic Republican, to, to deliver those commissions, Jefferson ain't going to do it. And what are they going to do? Roll tanks up? Not that we had tanks at the time, but what are they going to do? Come with armed battalion to sort of force Jefferson and Madison do it? They're not going to do that. It would have really showed the weakness of the Supreme Court. And so it's pragmatic. And on the one hand, he says, I'm not going to tell Jefferson to do something he's not going to do because it's going to show how weak the court is. But it's pragmatic too because he says, but in doing so, I'm going to create this thing called judicial review that actually gives this great benefit to the court. It's the legal method of structural analysis because it takes into consideration the separation of powers and the importance of the Constitution. And also, as you're reading the opinion, you'll see that there's a lot of textualism. That John Marshall goes in and he's reading the Constitution and he's really deriving its meaning, not from what the framers intended, although there's some of that, but from just the actual text of the Constitution as well. Okay, so here at the end, let's just think critically a little bit about judicial review. So you're thinking about judicial review, maybe think about the benefits of the Supreme Court exercising judicial review. And what are some of the drawbacks associated with it? I mean, definitely one of the benefits is that with the, if a law is unconstitutional, then the Supreme Court should defend the Constitution, even if that means, overturning the acts of a duly elected body, because, they are basically the protector of the Constitution. But a drawback is definitely that you have this unelected judicial body that, has this power to overturn the actions of an elected legislative body. And so you could basically have 350 members of the House and 75 members of the Senate and the president sign an action into law, and that you have maybe 5 out of 4 Supreme Court justices who rule that that law is unconstitutional and overturn sort of the support of a body that has large majority of support, basically says, nope, the majority doesn't matter. This very small select 5 justices can overturn the actions of this larger majority of people. And also think about are there any checks on the Supreme Court's power of judicial review? If they find a law to be unconstitutional, is there any next steps? One next step is we can amend the constitutions, basically saying that, embedding a law or a constitutional right into the Constitution, but it's incredibly difficult to amend the United States Constitution. I guess you could wait for another court to overturn, the ruling of a previous court and get rid of that precedent, but even that has some problems as well. And so I encourage you to check out Table 2.1 in our textbook. There will be a question on the midterm exam about judicial review, and Table 2.1 does a really good job of sort of looking at the benefits and drawbacks and the different arguments in favor and opposed to judicial review. All right, thanks a lot for listening, and I'll talk to you again soon.